So you've decided to leave your law firm. One of the first questions that likely comes to mind when leaving your partnership is whether and when you can tell clients, your firm, colleagues, and staff. As it turns out, there are some clear guidelines regarding whom you can tell and when. Like so many things related to a partner's departure, it can get complicated. It's important to know the general landscape, but then you need to analyze how the rules apply to your situation when leaving a law firm. First, your client's interests must come first. You have a duty to protect your client's interests at all times during any transitions, and so does your future former firm. This duty is not mitigated by your individual business considerations, by your old law firm's interests, or by your new law firm's interests. Second, you have duties to your old firm. As a law firm partner, you may have a fiduciary duty to tell your firm about your departure before you tell anyone else. This means that if you tell your clients or tell your team and staff before you tell your firm, you may be creating exposure for a claim for breach of fiduciary duty. Third, your partnership agreement creates obligations. Your partnership agreement most likely contains a notice provision detailing the requirements for how you must give notice to the firm and how much notice you must give regarding any departure. This means that if you leave before the notice period expires, you may be creating exposure for a claim for breach of contract, namely the partnership agreement. Fourth, you should check your state's ethics rules. Some states, such as California, Florida, Ohio, Pennsylvania, and Virginia, to name a few, have enacted specific ethics rules or have issued ethics opinions that create notice obligations or describe best practices for how to go about giving notice. With those general guidelines in mind, the tricky part is to balance these requirements in application to your situation. It's not difficult to imagine scenarios where these requirements can be at odds with each other. What if your client's best interests dictate that you leave your firm on 1 day's notice, but your partnership agreement requires 30, 60, or 90 days notice? What if servicing your client's matters requires that your team and staff continue their work uninterrupted, suggesting that you better find out before you go whether your team will remain intact? What if you were called a partner at your firm, but you have never signed any partnership agreement and do not have any ownership interest in the firm? From the law firm perspective, consider whether your firm has a valid client-centered rationale for a notice provision, which is permitted, or whether the notice provision is just a means to stifle competition by preventing attorney mobility and the departing partner's ability to practice law, which is not permitted and not likely to work anyway. The general guidelines outlined above are just the starting point. These scenarios and similar complicating issues are quite common. That means devising the right plan to balance these interests in a defensible way, which requires closely considering these potentially divergent interests before leaving the partnership. The good news is that you can create a departure plan that balances these interests, protecting your client's interests and meeting your obligations to your firm. You just need to plan ahead.